My name is Darcy Chemnitz. I'm the Executive Director of the LGBT Bar Association, and our call today is going to be what's next for transgender rights after the Fourth Circuit victory. On Wednesday, April 20th, the Fourth Circuit Court of Appeals issued a ruling in Grimm versus Gloucester. Is it Gloucester? Am I pronouncing that correctly, James?
Yeah, Gloucester. I'm with you. I'm not sure.
Okay. County School Board discrimination after they barred him from using the restroom matching his gender identity. While the ruling in Grimm was based on a school board decision and not the type of bathroom bill legislation sweeping the country, legal experts have asserted, and we'll be checking in with our legal experts here today, that the Fourth Circuit. So in North Carolina, we have a state whose governor submitted an amicus brief asking the Court of Appeals to uphold this kind of discrimination. We may hopefully see a change in its laws. So what does the decision in the Fourth Circuit mean for the broader transgender movement, and what can LGBT organizations and legal professionals and students throughout the nation learn from this ruling? We are now joined by two experts to discuss it. We are joined by James Essex. James Essex is the director of the LGBT and HIV project at the American Civil Liberties Union. James oversees the ACLU's nationwide work on LGBT rights, which includes litigation such as Obergefell v. Hodges, last year's mayor's decision, and U.S. v. Windsor, the DOMA ruling, and of course legislative lobbying such as fighting this year's onslaught of over 200 anti-LGBT bills in state legislatures. We also have Shannon, the legal director of the National Center for Lesbian Rights. Shannon is a longtime LGBT advocate and has served as lead counsel for a number of high-profile cases, including the 2009 Prop 8 case, California Supreme Court, Christian Legal Society v. Hastings, among many other cases. Minter has been the recipient of a number of awards, including California Attorney of the Year in 2009, listed as one of the 6 Lawyers of the Year by Lawyers USA, and both of these gentlemen have received the LGBT Bar Association's highest honor, the Dan Bradley Award. Welcome to both of you. Let us proceed, gentlemen. We only have a half an hour, and we've got lots to cover.
Go ahead, James.
Great. So, Darcy, so look, I'm thrilled to be here with LGBT Bar to talk about the Grimm decision. The case is captioned GG because they wanted there to be a confidentiality for the student, but he's very out. His name is Gavin Grimm. He's a junior at a public high school in Gloucester, Virginia. And he came out as transgender during his freshman year, came out to his family. And since then, has started hormone therapy, changed his name, and now lives fully as a boy. In the fall, a year ago, he got permission from the principal to use the boys' room at school, and he did so for about 7 weeks without incident. Parents of other students, however, complained to the school board about his using the boys' room. The school board ended up holding 2 different hearings over the course of a few weeks to get public comment on the issue. And that was, as you can imagine, a tough experience for Gavin because Gavin went to that hearing and he testified about who he was and why it made sense for him to use the boys' room. And he had to stand there and listen to other parents call him a freak, address him as young lady, and say other things like that are just incredibly profoundly undermining to his identity. And so he is a hero in my eyes just because at 16 years old, 15 years old, he had the stamina and the sort of personal fortitude to stand up to bullies like that in public. The board issued a new rule after those series of board meetings and said that restroom use is limited to the biological gender of the student, and that students, quote, with gender identity issues in the board's language could use either the restroom that accords with their birth gender, or could use single-user facilities that the board decided to create. So Gavin was not happy with that. Gavin felt profoundly ostracized and stigmatized by being told that he and he alone needed to use single-user facilities, or that he could go and use the girls' room. And he said, look, other people are not comfortable when I use the girls' room. I'm not comfortable when I use the girls' room. So he brought with a lawsuit challenging the new restroom policy by the school district under both Title IX, a federal law that bars sex discrimination by schools that receive federal funding, and under the Equal Protection Clause, because, of course, it's a public school and they're subject to the Constitution. The case started out with some difficulties. The district judge dismissed the Title IX claim outright and denied our request for a preliminary injunction that under the Equal Protection claim, preliminary injunction that would have required the school to let Gavin use the boys' room. The decision that we got earlier this week from the Fourth Circuit, on the other hand, is a wonderful affirmation of the legal claims and of Gavin and Gavin's identity. The court holds that Title IX requires schools to allow transgender students to use the restroom that is consistent with their gender identity, and holds that schools cannot force trans students to use separate facilities. It can't treat them differently than other boys or other girls. The reasoning of the Fourth Circuit's decision is based largely on deference to the Education Department's interpretation of Title IX and of Title IX regulations. And here's the structure of the law in the area. Title IX bars sex discrimination, as I said earlier, by schools that receive federal funding, which is basically every school or just about every school in the country. Regulations under Title IX say that it's okay to have restrooms separated for one set for boys and one set for girls, as long as the restrooms are basically equivalent. But the regulations don't address what restroom a trans boy or a trans girl can use or should use. And to address that ambiguity, the Education Department issued guidance in early 2015 saying that schools have to treat trans students consistent with their gender identity, including in the restroom context. And the Fourth Circuit's holding is one that is, as I said earlier, largely based on deference to that interpretation of Title IX by the Education Department. They ruled 2-1 that deference makes sense here. They remand the preliminary injunction issued to the district judge for reevaluation. One of the judges, in a concurring opinion, says that he would have issued the preliminary injunction himself if it were just up to him, or certainly says the appeals court could have done that. And the dissent obviously does not agree on the Title IX question or the preliminary injunction question. So that's basically what Gavin's case is about, the facts and the holding.
Well, Darcy, I guess I can jump in here. I just want to say that I'm just delighted to have a chance to congratulate James and his colleagues at the ACLU, and especially Joshua Block, who was their lead on the case and did such a great job arguing it in the Fourth Circuit, just for doing such a wonderful job on this case. And it really is a game changer. I mean, this is the first and only, so far, Federal Circuit opinion that addresses this really important question of whether Title IX prohibits schools from discriminating against transgender students, and I'm cooperative on that question. I think this is it's a death knell for the bathroom portions of HB2 in North Carolina. I think James is going to be talking more about that. But it's already just, this decision is reverberating in very positive ways all around the country. And just in the short time it's been out, we've already invoked it a number of times all across the country, including just today in Florida with the school district thinking of enacting the way the Fourth Circuit did. Is a really big deterrent to any other states or hopefully even districts adopting these really harmful policies.
Well, that's exciting news, and I tell you, when my staff first told me the Fourth Circuit had ruled, I said, no, you're reading it wrong. It's not the Fourth. We are just thrilled to bits to learn more about it. And James, special thanks for telling us about the individual whose heart and soul is part of this story. It is a good example of how lucky we are within the LGBT family to have such courageous young people and the support of their families. There wasn't a dry eye in this office as you were telling that story. Thank you.
Thank you. No, he's a hero.
Very good. All right, how shall we proceed, gentlemen? Shannon, do you want to pick it up from there?
Sure. I mean, I thought it would be important to talk a little bit about the great amicus briefs that were filed in this case. I mean, that's in addition to the excellent briefs filed by the ACLU. There were some powerful voices raised in front of the court briefs supporting Gavin, and I think the most important was the United States Department of Justice, filed a brief that just in the strongest, most unequivocal terms you could imagine, argued that Title IX must be construed to require equal bathroom access for transgender students. And that's a big deal because the Department of Justice's views, of course, carry enormous weight with the federal courts. So that in itself was another really historic thing about this case. Then it was also really wonderful to see that all of the nation's leading women's advocacy groups, and I do mean all of them, also weighed in to support Gavin. The National Women's Law Center, Legal Momentum, Equal Rights Advocates, Gender Justice, Women's Law Project, and several others filed a very strong amicus brief. And, that was important for one thing, courts really care about what those groups think about Title IX. It's a sex discrimination law, and they want to know what the women's legal advocacy community thinks. But it was also really important to rebut any kind of misconception that the other side is always trying to exploit, that there's any conflict between protecting women and girls and protecting transgender students. And having such a strong brief from the women's community really just knocked down that completely false argument. There was also a brief from medical and mental health professionals just making the point that transgender students have the same developmental needs and social needs as other students, and that just like any other young person, when you treat them differently, it really causes them serious harms. And they're not just transient harms, but they're harms that affect people for their whole lives. There was also a really great brief from school administrators from other parts of the country who have, in some cases, like decades of experience now with providing equal bathroom access to transgender students. And I think that was really important in case the court might have had any questions about, is this really going to work in practice? What happens if schools give transgender students equal access to bathrooms based on their gender? And it was good to have a brief that just said, nothing bad happens. In fact, it's a positive experience not just for those students, but for the entire student body. And then there was also a brief from GLSEN and some other groups that were just talk really directly about the experiences of transgender students and how they are harmed by discriminatory policies and how they benefit and thrive when schools treat them the same way as others. And, so the amicus briefs on our side were super strong. And then, James, I don't know what your view is, but I thought the amicus briefs on the other side were quite weak, and they were, just from some right-wing groups and a handful of conservative governors, and really made some rather outlandish claims. I thought that there was really no comparison between the two sets of briefs.
I agree with that, Shannon. I think that our side had, talked about practical experience on the ground, medical information and judgment that helped, and the other side was talking mostly about politics. And interesting, there was a brief from, I think, the governor of Maine and the governor of North Carolina and some other folks weighing in against us, but not, I think those came across as political documents more than really legal documents, which didn't help.
Yeah, Darcy, can I just jump in really quick? There was one quote from one of the briefs that just jumped out at me as so ridiculous and so sort of exemplary of the arguments they were making. So here's the direct quote from one of the briefs on the other side. Quote, "When I look at the origins of the transgender movement, I find John Money and Harry Benjamin, both bisexuals, who failed to condemn pedophiles and freely associated with them. When I look at sex education in schools, I see Alfred Kinsey and his colleagues, and I see pansexuality and embracing of pedophilia along with bestiality. And then it goes on to talk about the quote-unquote sexually deviant origins of the effort to abandon the concept of biological sex and adopt a fluid concept of gender identity. I mean, that should give you all and everyone listening just a flavor of just really how really absurd and outlandish the arguments were on the other side.
Thanks for sharing those with us. Where do we find both the amicus briefs online? Do we find them through the circuit court, or are they on one of your web pages?
Yeah, I believe that they are on the ACLU web page. If you search for Gavin Grimm or GG and ACLU, you should come up with a case profile page that includes that, and they're all also available on Pacer.
Great. And then for those of us in the law, I think, the jury is in about how those of us in the law are reacting to gender identity and expression. For instance, of the Law 200, 167 of our firms have gender identity included in their non-discrimination policy. 140 have inclusive health care. 137 have leave after surgery and cover hormones. And 117 have diversity trainings focused specifically on gender identity and expression. So I guess, Shannon, you're predicting that this is the death knell for HB2 in North Carolina. Is that right? Can you tell us a little bit about that?
I can, and then James, I hope you'll definitely weigh in on this. Yeah, but yes, I mean, one of the criticisms that was raised immediately, even before HB2 was passed, although there was, literally only a matter of hours for anyone to say anything about it, since the legislature rushed it through in such a hurry. But both immediately before and after it's been passed, many people have been pointing out, legal experts in particular, that the bathroom provisions of that law, and particularly the ones that are about schools, cannot be enforced because they directly conflict with federal law, which of course takes precedence over any contrary state laws. And we and others have been saying that Title IX, as interpreted by the Department of Education, requires equal access for bathroom access and locker room access for transgender students. So there's, HB2 is just on a direct collision course with that law. But one of the things that the sponsors of the bill said is, well, we don't think those regulations are correct, and if we had a federal court decision saying that, then yes, we would agree that we can't have this provision in the law. Well, now they do. Not only is it a federal court decision, but it is a federal appellate court decision, which carries enormous authority. So, the folks who put this bill forward and voted for it in North Carolina are now in a real bind, and I think everyone's hoping that they are true to their word, and that now that the federal courts have told them that their law cannot be enforced, that they will repeal it. But then, James, you all, of course, have challenged it in court as well.
Yeah, but I agree with everything you said, Shannon. There is a case, Carcano versus McCrory, that's pending in federal district court in North Carolina, challenging all the different pieces of HB2, but especially the restroom pieces of HB2, and the claims in Carcano are precisely the same claims that are in the GG case. So an argument that the restroom provisions are sex discrimination in violation of Title IX and in violation of the Equal Protection Clause. And the GG decision from the Fourth Circuit is, of course, binding on the Federal District Court in North Carolina. As to the Title IX claims, we think that the same general reasoning applies to the equal protection claims. And so I am very optimistic that we are going to, when the case gets a little bit farther along in the process, that we are going to get good rulings. I think we should get good rulings based on GG in the Carcano case, and that will take out at least the restroom portions of HB2.
Well, that's exciting news. I think that we're all breathing a great sigh of relief on that. And regrettably, we've only got 10 minutes left here. If individuals have questions, you may email them to darcy@lgbtbar.org. Any questions you have, please do not hesitate to email them to darcy@lgbtbar.org. And let's just go through this last item as how is this going to, now we know what the law is in the Fourth Circuit, so let's go a little bit more broadly and think about these pending bathroom bills. I think you've said you've already been invoking this law out there. We're hoping that this will stem the tide of new bills being introduced. Isn't that right?
Yeah, Darcy, that's exactly right. I mean, I guess I really can't stress enough how important it is that we now have a federal appellate court decision that has squarely addressed this issue. And, of course, it's directly binding, as James was just saying, on all states in the Fourth Circuit, and it certainly does seem like it is going to be pretty much completely dispositive of the bathroom-related claims that James and his colleagues at the ACLU and Lambda have put forward in the challenge to HB2 that was filed, I guess, earlier this month. But look, that decision is going to carry a lot of weight in other circuits as well. The decisions and particularly, I think, the extensive analysis that Judge Davis provided in his concurring opinion in this case really provides a roadmap for other courts who are going to be looking at this issue. And, you know, I know that we're feeling very confident right now advising any school district anywhere in the country that adopting a discriminatory policy like the one that the Fourth Circuit just held to be invalid is going to put them in violation of federal law. They're certainly going to be inviting litigation, and they are almost certainly going to lose. So, you know, we're really in a different world after this decision than we were before, and it's a much better and safer world for transgender students now.
That's wonderful. So one of the questions I've received is, does this ruling provide support for the interpretation of other statutes prohibiting sex discrimination, such as Title VII? Can you both speak to that, please?
Go ahead, James.
So this is James. So look, I think it does. I mean, I think there are, so we've got the Fourth Circuit saying that sex discrimination, the federal ban on sex discrimination in the Title IX context, there's no reason it would be different than in any other context, covers transgender people. And in other cases, there's been sort of like people have, there's been a discussion about whether it does or doesn't cover transgender people, and a bunch of the briefing that the advocates on both sides submit to the court spends a bunch of time on, is gender identity covered within sex or not. This decision takes it as just a given. That of course they don't even talk about it. The concurrence talks about it some, but the majority doesn't even bother because they take it, I think, as that obvious, and that's something that we're going to. All of the advocates are going to export to other laws and other courts. So I think it very much helps with that. Shannon, what do you think?
Absolutely. I mean, it is exactly the same legal question and the same legal issue under Title IX, under Title VII, and even under equal protection sex discrimination law. So getting a positive precedent in one of those areas spills over to the others, no question.
And another question for you here. What should public universities in North Carolina do now that the Fourth Circuit has ruled, but HB2 has yet to be struck down by a North Carolina court? Should they continue to comply with HB2 for the time being, or are they safe to violate HB2 in accordance with Title IX? It's asking a little bit of legal advice rather than legal information there, but do you have general legal information you could share on that?
I feel very strongly about that. I have a feeling James does too. They absolutely should be following federal law. I mean, they should have been anyway. And now that there's been a federal appellate court decision, they certainly should be complying with federal law, and they should not be enforcing HB2. And if they do, they're going to be sued, and they're going to lose, and they're going to be liable for, attorney's fees. I mean, it's really irresponsible to do anything other than follow federal law, and they already have been sued. James, you should.
No, I completely agree.
Yes,
the supremacy clause means something here, and that's what it means. It means that the state law is not a defense and not a defense to a claim, but is not something, state law is not what should be guiding state officials like the people who run UNC. Okay,
another question for you. Federal courts have repeatedly said transsexuals and transgender individuals are not protected classifications. This is about protected classifications with respect to the meaning of sex or workplace discrimination in an employment context. Does this Fourth Circuit decision affect that perception of protected classifications?
Go ahead, James.
Yes, it does. But let me just back up for a second. I mean, I think there are a number of different concepts that we could be talking about here. One is, does government discrimination based on against transgender people trigger heightened scrutiny under the Equal Protection Clause, or separately, do the bans on sex discrimination cover gender identity and transgender people? This absolutely helps with the scope of the sex discrimination bans, both in terms of the Constitution and in terms of statutes, because this is a court that says that discrimination against transgender people or on the basis of gender identity is a form of sex discrimination, even in the restroom context. But if we're talking about constitutional rulings, like does government discrimination trigger heightened scrutiny, I think this is also something that, once we get to the equal protection context, should be recognized as sex discrimination, and sex discrimination, of course, gets heightened scrutiny under the Equal Protection Clause. And I think that, I also think that there should be, that the right answer under the Equal Protection Clause is that discrimination against transgender people should get heightened scrutiny, even if you don't think of it as sex discrimination. But I think the sex discrimination paradigm is right and is going to win, and GG is helping.
Yep, James said it all. I completely agree.
See, and everybody thinks theirs. Agree. Another question for you. Can anyone predict a time frame for overturning HB 2 by the courts, given that North Carolina is probably does not have an ability to revoke the law legislatively? Any better of an idea of what our time frame is going to be in the courts in North Carolina, gentlemen?
Well, this is James. I'll jump in. So, look, I think that it is likely. I mean, the Carcano case is going to get to a merits phase, I think, pretty soon. And I think that the GG decision is going to, gives us a very strong indication of how that piece is going to come out. How long the state decides to fight is we will all see together. But Darcy, I want to go back and just address one of the things you said in setting up that question, which was an assumption that the legislature is not going to fix this. A week ago, 2 weeks ago, it was clear to me the legislature was not going to fix this. The continued and growing backlash from businesses, from performers, from conventions, and today from President Obama speaking in London, was asked about the North Carolina law and the Mississippi law and said they should be overturned. And note, he didn't say repealed, he said overturned. But I think that the pressure is growing such that when the legislature comes into session on Monday, there will be repeal bills, and I think that they will get more attention than I thought just a couple of weeks ago. And the challenge for all of us is going to be to make sure that if something passes, it's not a half measure, but it's a full measure in terms of a repeal.
Darcy, can I just jump in there and echo what James just said and encourage everyone on the line to help keep the political pressure on in North Carolina? I think that is really important because they're feeling the pain, and rightly so. And I think the general view is that there is a very significant chance that the legislature is under so much pressure, and now particularly because of the Fourth Circuit decision, it's so clear that huge portions of the law are flatly contradictory to recently issued binding federal court precedent, that they actually really may take steps to repeal it.
Yeah, it's a whole new ballgame, isn't it? Thanks so much for that analysis and those insights. I would like to personally thank James Essex, who made time out of his busy schedule to join us today. I believe, Shannon, you're out on the road as well, so thank you both so much. And we know how busy you are doing your cutting-edge litigation calendar, and so thank you for joining us. The National LGBT Bar Association cannot continue putting together quality programs like this without your continued support. If you'd like to see more cutting-edge legal analysis, please consider becoming a member of the bar or going online and providing us with a financial gift to support our efforts. To learn more, please go to lgbtbar.org. Thank you, everyone.